Welcome to the DRE Way, where we discuss current events, frequently asked questions, and legal matters. When it comes to law, the only way is the DRE Way.
Darren, I want to thank you for coming back on the podcast today. It's great having you again.
Great to be here. Thank you, Matthew.
Not a problem. So in the news lately, there's been a lot of talk of Johnny Depp and Amber Heard. And I did want to ask some questions around that because there's some stuff I don't understand. And I'm pretty sure that means a lot of our clients and people who follow you don't understand it either. First thing I don't actually understand, and we get a lot of calls on this all the time, is defamation and what it actually is and isn't, and how you would define defamation in a case.
Okay. Well, there's also another big high profile case taking place at the same time with regard to Blac Chyna versus the Kardashian family. Also another defamation case here in Los Angeles Superior Court. But you may recall, no matter where you grew up, that either your parents or your teachers, church members, elders, warned us that sticks and stones may break my bones, but words will never hurt me.
Right.
It's incorrect. As you get into the legal world and as adults get more serious about making statements that reflect very poorly on others. And so therefore, the legal system has developed a construct where by somebody who's been defamed can sue another person for defamation. And defamation has a simple definition with some complexities, but essentially it means that there was a false statement that was defamatory, published at least to one other person. So if it's just me and you talking and I make a false statement about you, that's not defamation. But if I tell somebody else, just one other person, that is defamation. And it needs to be a fact, not just an opinion. So I need to make a false statement, not only a false opinion. If I say you're not a really nice guy to somebody else, that doesn't rise to the level of defamation. If I say
that's an opinion.
That's an opinion. And one of the most important aspects and the biggest hurdle when you get into the legal realm of this issue is proving damages. Because when you go back to the childhood statement, words will never hurt me, you don't only have to prove that the words were false, but you have to prove that it had a damaging effect to your bank account, to your business, or to your reputation in the community. And that's usually the more difficult part. And there's two different forms of defamation. It's slander and libel. And really, they all mean the same thing, but slander is from an oral statement, a spoken statement, whereas libel is a written statement when somebody writes something false about you.
Like a Facebook post, something like that.
Right. So in the case of Johnny Depp, if I recall correctly, Amber Heard, I think, penned an opinion letter in a publication.
Yep, the Washington Post.
Washington Post. It did not mention Johnny Depp by name. However, if the receiving party of a false statement can identify who it's about, and you can closely associate the statements with the person, even if they're unnamed, that is definitely a viable defamation claim. So, everyone here knew, apparently, or allegedly, that she was talking about Johnny Depp. But when we start talking about the Kardashian family, or we start talking about politicians and Johnny Depp, this is where the complex aspect of the issue comes in, because they are considered public figures. Correct. And when there's public figures, you actually have to prove actual malice on behalf of the publication that published this statement. So while Amber Heard may have penned the opinion letter, it was published also by the Washington Post. So if he wanted to sue the Washington Post, there's a component there where essentially the standard of play in the legal game rises. You can't just prove that it was a false statement, it was defamatory, it was published to somebody else, and there's damages, but you have to prove actual malice. And actual malice means that the publication here, the Washington Post, if they were sued, knew that the statement was not true.
And then published it.
Or acted in reckless disregard of a statement. For example, if a person were to publish an article in the Washington Post that said a politician had a child out of wedlock, and they did no investigation whatsoever to determine whether or not that was a true statement or a false statement, that would be considered potentially reckless disregard. And so those two elements have to be proven when you're dealing with a publication about a statement about a public figure.
Okay. That certainly makes sense. So that's why he's suing her and not the Washington Post, because they published her statement, but she's the one who made it. I did read the statement. There's some alluding to it that if you know their history, it's very obvious that it was about him, because she does date her time when she became the public figure for domestic violence with women, which was the same time she divorced Johnny Depp and filed a restraining order against him for domestic violence.
Right. So thereby, judging and determining and deducing the actual facts that were laid out, who they're talking about. So that there was a target and it was clear who it was talking about, and that would subject it to defamation. But there are some defenses with regard to defamation, and truth is one of them. So if you make a statement about somebody, it sounds terrible. It was a fact, not an opinion, and it defamed them, but you don't have a claim for defamation because it was true. Correct. If you had a bastard child out of wedlock and it was true and verified by a birth certificate and it was published, then that's an absolute defense.
Truth. It's not. Right. It's just unfortunate.
And then back to the public figure and publication issue, actual malice would be a defense by saying, hey, I didn't know that it was false, or by saying we did a thorough investigation and we determined it to be true. It turned out it wasn't true, but we didn't act with reckless disregard. And the one that comes up a lot lately here at my office is a privileged statement. So if one person says another bad thing about another party in litigation, that's privilege. Let me give you an example. I have a divorce client, and there are some pleadings, meaning statements that were filed in court, that are alleging that my client, who's the husband in a marriage, is hiding money or hiding assets and committed tax fraud and mortgage fraud. That's not a defamatory statement in terms of being a viable claim because it was made in the context of litigation. If a court or a judge presiding over a trial makes a statement that could be presumed defamatory, that's also privileged. And if a politician in a legislative chamber makes a statement by somebody else, that's privileged. So in those cases, you can't sue for defamation.
Okay. So there's a lot of this in the media right now. It's everywhere. And in an instance of a Kardashians or Johnny Depp and Amber Heard, people who are on TV all the time, they're professional actors. You could call them professional liars because that's what they are, is their job. How difficult is this for attorneys to be all this testimony and things going around. How can you even begin to know who to believe? You're talking two people who act for a living and very well at it.
That comes down to what we call a credibility contest. And, it's not uncommon to have two different stories when you get into court. And that's why you got there in the first place. People took such opposing and adverse positions in an issue or a matter, and they ended up inside of a courtroom. Who to believe in this case, you're going to have to, determine that for yourself. And that's the job of a fact finder. The fact finder is a judge if it's a bench trial, and the fact finder is a jury if it's a jury trial. You have to determine whether or not their body language, their facial expressions really exuded truth and accuracy. And if they didn't, then they might find them incredible, and whomever was more credible might win. But you don't just have to believe these statements, because in a defamation case, it's a little bit more objective. The statements were made and he's contesting whether or not they were true or not. But the issue is that because the statements were made and published, it tarnished his reputation and damaged his ability to get more jobs in the industry. And Correct. He's suing for that very reason. But in addition to that, he's suing an individual for $100 million, as I understand it. I don't think she'll ever amass $100 million in her lifetime. So he's seeking damages that, if even proved, are going to be very hard to actually retrieve.
Now, can they reward less damages even though he's seeking that much?
Sure. I mean, that's called a prayer for relief. So you're saying, hey, here's all of the movies that I was talking to producers and directors about. Here's how much I was going to be paid. And I determined that because the last 5 years I was paid a certain amount. And therefore my damages are $100 million. And the jury or a judge may come back and say, you know what, we took a look at all of it too. And you're aging and you gained a lot of weight and you've been, having some distractions with regard to your life. So we don't think you would have made that much. And we don't think that the article damaged you that much. So yeah, we believe it was a false statement and, it defamed you and it hurt your business. And we're going to award you $500,000. That's very possible.
Okay, cool. So one of the questions I want to come back to, and this is something we actually even discussed in our last podcast with the Kyle Rittenhouse situation, is some of the actions of the actual attorneys who are in the case, particularly Amber Heard's lawyer, has been openly mocked, very much so on YouTube, on Twitter, for the way he's dealing with the courtroom, where it's asking Johnny Depp the same question 4 times. And Johnny Depp was like, yes, for the 4th time. Yes. Or the one that got me is, and this is kind of a question about objections, but he objected to his own question and the judge called him on that.
Yeah, I haven't followed the case closely enough to go into every detail, but I do know what you're referring to. So first I'll address the objection that should have been raised, which would have been asked and answered. So if one question was asked and the person that is on the witness stand answered that question, and then the question is asked again, the lawyer for the person on the witness stand should stand up and say asked and answered. And almost every time that objection will be sustained. Sustained means that the court agrees and therefore the other attorney can't ask the question again.
Okay.
So in this case, it seems Johnny Depp did his own objections, right?
Yeah.
There are some nuances because maybe the same kind of question was asked, but in a way different manner. And that's an assessment that the judge has to make. But if you're seeking the same type of answer, the question can't really be designed too different. So most often you ask the same question again, that will be objected to and it would be sustained and you can't continue to ask that same question. With regard to the one that you're talking about, that's a whole nother subject in the legal industry called hearsay. But the attorney opened the door to hearsay by asking Johnny Depp what somebody else said out of court. So any out of court statement that is offered to prove the truth of a matter is called hearsay. And it's not allowed in court because we want to have that person come in and we want to be able to say, did you say something or did you not say something? Not ask somebody else what they said. So he asked a question that had embedded in it hearsay and Johnny Depp answered it. And then the attorney said, objection, Your Honor, hearsay. And the attorney said, you asked a hearsay yielding question. So
right.
That was not the best look for that attorney. I certainly don't want to disparage any attorneys working inside of a courtroom, especially when all the cameras are on. And
yeah, there's got to be a lot of pressure around that.
There's a lot of pressure there. And, he may just have, it slipped his mind. And then he's trained to always object to hearsay when somebody says something that somebody else says, but he forgot that he asked it in the first place.
Sure. And in a case like this, I mean, you are talking 100 million on the line. That's a lot. And so he's probably he wants to be as argumentative as he can to disprove Mr. Depp's case in this situation.
Right.
But he ended up doing it to himself.
Right.
The other one I wanted to ask is they're predicting this trial is supposed to be about 6 weeks in total length. Is that a long time for a trial or short? That seems like a long time for me.
For a defamation case where there's not a ton of expert witnesses that need to come in, there's not a lot of dense evidence, for example, DNA evidence, investigatory evidence. 6 weeks is a very long time. To give you an idea, the Kardashian Black China case wrapped up in a total of 2 weeks from the time that you pick a jury till you get a jury verdict. So 2 weeks is going to be a more common case length with regard to a defamation claim like Johnny Depp's.
Okay, great. You actually made an interesting comment there that I noted is, how do you get an impartial jury with people this famous? I mean, Johnny Depp was Captain Jack Sparrow, which almost everybody's ever heard of. Like, how do you find somebody who's impartial? That has to be very close to impossible to find people who don't like him as like being impartial.
The practical answer of that is you probably don't find anybody that's impartial. But what you need to do is be able to find people that are willing to come in and provide an impartial assessment so that the participants have a fair trial. And that is possible, where you could come in with some predispositions, but tell the court by declaration and under oath that you will do your best to be impartial, and you will try to take any predispositions and put them aside so that you can assess this objectively and not subjectively. And I think a lot of lawyers don't understand that. I'm a more practical attorney, and I think what they do is spend a lot of time in voir dire saying, did you watch the movie? If you did, you can't be on here because you're going to be impartial. Do you know who he is?
It's going to be everybody.
Does your children have, toys from the movie? Did you ever go to McDonald's when they had a special and get a cup? All that kind of stuff. And they don't want them. They don't want them. I would say try to find people by looking at their backgrounds, understanding what their interests are, whether they're educated or not educated, what life experiences that they had, and then understand you're going to have impartiality coming in. What I like to do is say some people are Apple people and some people are Android people, right?
Right.
But can you, if you had to for 2 weeks, use an Android, or would it just be impossible? There's no way, I'm not even touching it. And I say that you can do it, and find the people that you think can set those biases aside and provide an impartial and fair trial to those participants.
Great. And I think you made an interesting point about a fair trial, because there is right now Amber Heard's attorneys expected to make a motion to throw the case out.
Right. So when I was talking earlier about fact finders, the fact finders determine whether or not a fact occurred or didn't, and if that sways the case. But legal issues are resolved purely by the court. I believe that motion was made, and I believe it was already denied, if I'm not mistaken. But that motion would simply be that it needs to be dismissed for whatever legal reason based on what's already transpired in the trial so far. And most everybody does that, when you reach that stage, because, it's a tool that you have in the toolbox. So you're going to absolutely bring it out to try to use it. The percentage success rate is not very high. And so therefore it usually goes nowhere, but it also preserves the record for appeal. So should this thing go against that attorney ultimately by the result of the actual judgment from the jury in this case, and they want to go appeal it, they can say, hey, the case should have been thrown out for this reason, and the trial judge didn't do it, and that could provide them a basis of appeal. So, that's just a matter of course. It's standard, it's common. And any attorney would do it. If you don't do it, you could subject yourself to an ineffective assistance of counsel claim later. So you have to do it, because then you didn't use one of the tools that you had, right?
Right.
So you're going to give it a shot. And in this case,
so more than anything, it's protecting her right to appeal the case should she lose it.
It's first, pursuing a position that you believe in and you think that it really should be dismissed based on whatever argument that you're making. But then knowing that even if you lose it, because you felt so strongly about it to begin with, if this trial case goes against you, then we want to appeal it. We can appeal it on the basis that that trial judge should have dismissed it for our arguments.
Got it.
Yeah.
Okay. Well, I think that's really enlightening. I got a lot clearer image of kind of what's going on, and I do appreciate your time today. I know you've got a lot going on your plate and a lot of things going on. So we'll go ahead and wrap up today, but I do appreciate this. I think this will be great for everybody to kind of understand a little bit more of the legality of the things going on.
Awesome. See you next time.
I appreciate it. Thank you, Darren.
Bye.